Good afternoon, everyone. Thank you for attending our CLE today. I am Catherine Saldana. I'm mentor attorney with the Dallas Volunteer Attorney Program. For those of you who are new to DVAP, our program is a joint project between the Dallas Bar Association and the Legal Aid of Northwest Texas. We serve those who live in poverty in Dallas County by partnering volunteer attorneys with our clients. Today's CLE is an area of law that is different from other areas. Family law cases mean more to our clients than any other type of lawsuits. This is their lives, their children, their families. Today, we're fortunate to have Ms. Elaine Mosier speak with us. Her private practice specializes primarily in family law and animal law, and she is also trained as a family law mediator. Her work experience is prior to her to start going solo in her practice, she joined Legal Services of North Texas, formerly known as Legal Services of North Texas, which is now Landwit, as a staff attorney in 1996. She later became a DVAP mentor and then was appointed managing attorney of DVAP. She received her Juris Doctor in 1993 from Texas Tech School of Law. For many years, she's been a frequent speaker with the Dallas Volunteer Attorney Program, speaking at our Nuts and Bolts CLEs, our Amicus Attorney and Ad litem CLEs, as well as CLEs such as the one today. Elaine is a gourmet cook and also an avid reader, and she has several pets. Please join me in welcoming Elaine.
Good afternoon, everyone. Thank you so much, Catherine, for that lovely introduction. What I'm speaking about today is something that, whether it's in private practice or accepting cases through legal aid, is probably one of the most, I would say, desired cases that you'll run across, which is, I need to get divorced. I don't have any children, we don't have lots of property, and we need to get divorced from each other. I tell people all the time that if you are looking to increase your competence in a particular area of law, legal aid is a wonderful way to do that, because you have the opportunity to assist people who desperately need your help, and it can teach you a new area with which you might not be familiar, and it can teach you in a less cruel way than just appearing in court and trying to research and find out on your own how to do something, because you have the opportunity to have mentor attorneys such as myself, or other mentor attorneys who are much smarter than me and can probably give you way more information than I can. But that being said, I will put in the chat box my cell number. I don't know if it's on the resume that, I don't know if the resume was even forwarded to you, so it doesn't matter. But if you text me, I will answer. So please feel free to use my cell and to send me a text if there's a particular bit of information that you need. So I will now jump into doing a no kids, no significant property divorce, and just kind of walk you through what you need to do. It's easy once you know the steps. It can be stupid hard if you don't know the steps. So the first thing that you need to do is meet with your client and get the name. I know this sounds dumb, but you have to get the full legal name of the respondent, not the name they go by. You can't divorce, Boogie Davis if Boogie is his nickname that he goes by and everybody knows him as Boogie. Well, that's not his real name. So you need to divorce, James Henry Thomas, not Boogie Thomas. Also, you need to find out if any children were born during the marriage who are not of the marriage. And let me explain to you what I mean by that. That if wife becomes pregnant by someone other than her husband, that is still considered a child of the marriage. And in my opinion, that takes this case away from being a simple no kids divorce at that point, unless there's already a court order which establishes that another man is the biological father of that child, and that court order can be attached as evidence that there are no children who were actually born of this marriage. The next thing that you need to know, and this is mostly for statistical purposes, you need to know your client's date of birth, the petitioner's date of birth. You need to know the petitioner's driver's license number, their state or state ID number if they don't have a driver's license. Now, I have done many divorces for people who are not legal citizens of the United States. So you are allowed to just write none in the original petition. If you'll note, I included an original petition in the packet of documents that you received. And in that original petition is a place where you can put the last 4 digits of the petitioner's social security number and state ID or driver's license number. If you are divorcing someone who does not have legal status in the United States, which you are absolutely allowed to do, you just simply fill those in with none. You also have to have the date of marriage and the date of separation. And date of separation, especially, I tell people, sometimes people are very shaky about the date on which they separated. They say, well, I don't know that it was, I kind of decided that I was going to leave on, January the 15th, but I didn't really get out of the house until January the 30th or January, or February the 10th. So what I tell people with regard to the date of separation is that it's important, but it's not world ending if you get it slightly wrong. So whatever date they consider to be the date of separation, use that. Just say, if you decided that you were separated on January 15th, because that was the day you were originally going to leave, and as far as you're concerned, the two of you were not together anymore after that date, then that's your date of separation. Now, the only time that date of separation can be problematic is if there's something of significance that was purchased between periods of separation. But given that what we're focusing on today is no kids and no significant property, that shouldn't be a huge issue for the clients that you would be dealing with. The next thing that you need to find out from your client is in what county this really is purely for statistical purposes. You want to find out in what county they were married or in what state they were married if they were not married in the state of Texas. The reason that you need to find that out is that on what all the clerks and most people at the courthouse call the Austin form, which is actually the form relating to family information, it wants to know in what county or in what state people were married. So it's good to just go ahead and find that out up front, so you're not scrambling at the end to fill out the information that's required on that form. Also, I always ask people this question: are you buying a house? And if you are, when was the house purchased? Same for any piece of land that may have been purchased, that there's no house on it, but it's just open land. In my opinion, you're not talking about a simple divorce if they say, yes, I own some property in, Kaufman County that we purchased during the marriage because we thought maybe someday we'd build a house on it when we were going to retire, or some lovely idea like that. Again, that takes it away from being a simple divorce in my mind, because then you're talking about dividing things of significance, and real property of any sort is considered significant under the law. So just be aware that you're dealing with something a bit more complex if they say, yes, we bought a piece of property, or yes, we do own a house together, or we're buying a house together. I find that many people, if they still have a mortgage due, don't describe it as home ownership, they describe it as buying a house. So be sure and ask that question both ways. Do you own a house? Are you buying a house? Because I learned the hard way that if I just ask, do you own a house? They'll say no. And then I might go along for months without realizing that a house is being purchased. So be sure and ask the question in both ways. Then you need to figure out what are the pots and pans that need to be divided. What I mean by the pots and pans are your couch, your bed, your TVs. Most people don't have televisions or electronics that are of such significant value that they truly need to worry about it, other than, oh, I want my TV from the living room, or oh, I want the TV from the bedroom. Similarly, you need to find out, who's got a car. Does the car have a lien on it? Does it have a payday loan on it? Is it still being purchased through, GMC or Chevrolet financing, or through some other financing agency, through like one of those tote your note lots? Because that debt also needs to get divided in the divorce. And I strongly suggest that you have your client write down a list of things that they would like to be awarded in the divorce. Like, I want the pictures out of the living room, and I would like the couch from the living room. And now that may be something that needs to be negotiated with the respondent at some point, but at least you have a starting position when you do that. You also need to find out if your client gets along well enough with their soon-to-be ex-spouse that they will forward the waiver and the original petition to their spouse, or is that something that you need to do? Typically, what I do on simple divorces is I file the petition, and it's listed in the petition that I've provided that we presume that the respondent will sign a waiver. If the respondent does not file a waiver, then we are asking that he or she be served. If you have an address, go ahead and stick it in there. If you don't have an address, just put serve some wherever they may be found in the state of Texas. And I've put some information about service in my list of steps, because, as you will find out, service in family law cases is one of the most important aspects of the case. You cannot finalize it until you are able to prove that you either have a waiver, which is notarized, and that notarized waiver has been filed after the original petition was filed. If it's filed jointly with the original petition, it is invalid. So what I tell people is, if you have because sometimes people will come in as a couple and say, we want to get divorced, and he's going to keep what he's got, and I'm going to keep what I've got, and we don't have any children. And so this is, super easy, and it will be. However, if you accidentally do what I have seen people do before, which is allow the respondent to go ahead and fill out and sign and get notarized the waiver before the original petition is filed, or get it signed and notarized the same day that the original petition is filed, the clerks will often reject that waiver, as they should. Unless you can literally prove that you got a copy of the original petition, gave it to the respondent the exact same day that the petition got filed, and that the respondent then ran off to a notary and got the waiver signed, 2 hours after the petition was filed, and then came back and filed the waiver. But in order to avoid having to come up with any kind of proof or evidence of that kind of thing, I tell people the easiest way to do it is don't allow anyone to sign the waiver for 24 hours after the divorce petition is filed. That way you don't have to worry about it. The notary is a day later, it's filed sometime thereafter, it just makes your life easier. Now, if you're doing this case through legal aid, typically you would be using an affidavit of inability to pay costs. And if you do that, I strongly suggest that you type or write or put in the header or the footer that you are handling this case through legal aid. The reason is that the Dallas County clerks have begun challenging affidavits of inability on a pretty regular basis. And there's no point in you and your client having to show up for a hearing to decide whether or not the affidavit will be granted or challenged for cause. If you note that you've taken the case through legal aid, they are much, much less likely to challenge. And in fact, I had one where I accepted the case, filed it. I had written that I accepted the case through legal aid, but somebody just didn't notice it. And when I notified the attorney for Dallas County who was working the challenge, he was like, "Oh, okay, I'll just dismiss it. I'll dismiss the challenge since you've taken the case through legal aid." So typically they're the county attorneys are totally on board with the fact that affidavits are pretty much always valid when they come through legal aid. So it's just a good idea to note that on the affidavit so that you don't end up getting a challenge unnecessarily, excuse me. So once you filed the divorce, that's when you provide your file stamp copy of the original petition to your client, and hopefully they're going to get them to the waiver, or you forward it to the respondent yourself. Hopefully you can do it via email. Strongly suggest that if you have to do it through snail mail, that you include a postage paid envelope for them to return the waiver to you. I find that it is just almost impossible to get people to get me a waiver back, even if they've gone and gotten it notarized. If they don't have an envelope with postage on it to send it, they just, it's like sitting on their dresser or something where they just, they have all great intentions of sending it and they never do. Also, if you have a respondent who's incarcerated, in almost every jail or prison in Texas anyway, the librarian is typically a notary. So if they need to have their waiver notarized, they can do it by going to the law library and talking to the librarian and setting a time when they can go in and sign and get their document notarized. Also, I suggest that when you send out the waiver, that you calendar about 20 days out from the time that you send it, so that you can remind yourself to double check as to whether or not they've actually returned the waiver. Because if they don't return the waiver, you need to start worrying about getting them served. And that means sending a letter, e-filing a letter, with the clerk's office. And you have to send back a copy of the file stamped original petition. I never understand this because they absolutely have access to it in the courts, in the court's file system, but they will not issue citation on a petition if you don't send a copy, e-file a copy of the file stamped original petition along with your letter requesting that citation be issued. I will tell you that typically, if I'm doing it on affidavit of inability, I send not only a copy of the petition, but I also send a file stamp copy of the affidavit of inability to pay costs, so that they won't charge me for the citation and they won't charge me for forwarding it to whatever constable's office, you might have to use for getting service completed on the respondent. So I typically just go ahead and send both of those. Otherwise, if you're not on affidavit of inability, it's $8 for citation, and then ask that they return the citation to you via email. And you either pay your private process server, or you have your client pay the constable's office to get the respondent served. Now, if you're using either a private process server or the constable's office, but certainly with the constable's office, you need to have a physical address where you're planning on having the respondent served. I have in my years of practice, I have occasionally gotten a constable to do service for, I had a guy once served in a blue van that he kept parked on a particular street every night because he was sleeping in his vehicle, and he went to work at like 7:30 every morning. So the constable actually got to that place where he parked the van every night and knocked on the van and got the guy served at like 6:30 a.m. before he left for work. But trust me, constables who will do that are few and far between. So if you have a physical address for someone, it's a much, much easier task in getting them served. Now, because we have a mandatory 60-day waiting period for a divorce to be finalized in Texas, you have some time, honestly, to kind of fool around with getting somebody served, but start thinking about it immediately. That if they don't sign the waiver, that after about 20 days, that you then start thinking about how you're going to get him served, because you will be shocked at how quickly 60 days will run. And then your client's standing there going, when are we going to finalize everything? And you're like, well, I haven't got him served yet, so I don't know. Because of course you can't finalize until you've gotten someone served. Now, if you have to have the respondent served, just a few quick things about service: that the return of service has to be on file for at least 10 days prior to the prove up or the date of finalization, and his or her period to answer has to have run, meaning the respondent has Monday next following the expiration of 20 days from the date that they were actually served in which they can answer. Now, I'm going to give you a truth be told. Every court I have ever been in, if somebody misses their answer period, but the prove up hasn't been done yet, the 60 days haven't run, or you haven't made it into the courthouse or haven't made it onto the Zoom prove up docket, and the respondent scurries and files an answer, but after their answer date, the court will absolutely accept it. And there's an answer, and you then need to make sure that you have the respondent's signature on that final decree of divorce, or you're going to have to set it for trial. Now, what I tell people all the time is, even if they sign a waiver, if you can get the respondent to sign the final decree of divorce, do it. It is so much more helpful. Then later they can't come back and say, well, I didn't understand that that's what that meant, and I want to file a motion for new trial because I'm all confused because I thought that I was going to get to drive, the nicer car, and she's the one who ended up with the nicer car, or he's the one that ended up with the nicer car. So go ahead and get the respondent to sign off. That's another thing that, sometimes I have seen many times, and these are totally valid decrees, where an attorney or whoever is preparing the final decree of divorce will just do what I call general wrap-up language, saying things like, you get all the vehicles in your possession, you get all the bank accounts in your possession. If at all possible, if somebody has a bank account, get the last 4 digits of the bank account, get the bank that it's at, if it's Chase Bank, if it's Bank of America, if it's Chime Bank, whatever it is, and put in there that wife is awarded the Chime Bank account ending in 1234. Husband is awarded the Bank of America bank of account ending in 5678. It just makes it clear. That way there's no confusion later on about who has what. Same with cars. Go ahead and award the actual car that somebody drives. Deal with the debt. If it's, I have this car and I have one of those payday loans on it, then award that person the car and award that person the payday loan. And the other thing that it's a good idea to do, especially if there's debt associated with the car that's going to go along with the car, I always tell people, if the car is jointly in, for example, my name and my husband's name, the car is in both of our names, and I'm going to award him that car, or I'm going to agree that he has that car and he's going to take the debt associated with that car. Me, not him, I want to go down to the tax office and show them a certified copy of my final decree of divorce so that I can make sure that that vehicle gets transferred into his name, so that that payday loan company or GMC financing or whatever it is doesn't try and chase me down because they want me to pay for that car, that dumb car that he's driving, and he decided to quit paying on it. So I always tell my clients, if you're awarded something and it has debt associated with it, absolutely take the time to go and make sure that, as far as the county tax authority and anybody else is concerned, they know that that was awarded to your spouse, and change it over into the spouse's name if you can, so that you're not having to deal with somebody chasing you for that debt. Now, the other thing that everybody needs to understand is the way that a state court awards debt literally has no meaning to the debtor. So let's say they have, and I see this happen all the time with credit cards. I've got a credit card with $10,000 on it. That's my Dillard's card. And that Dillard's card is in both of our names. And I'm awarded the Dillard's card. Well, and I'm also awarded the Dillard's debt. And so I've decided I don't want to pay Dillard's anymore. I'm sick and tired of it. So I just let that lapse. And I'm going to just, hope eventually Dillard's writes it off. And then I find out that Dillard's never writes anything off. They hate doing that. It makes them mad. So they always send attorneys after people. Well, my ex-spouse may find out that they're going to send an attorney after him as well, because if the card was in both of our names, and even though I'm obligated to pay the debt, I didn't, Dillard's will go after him. So you need to make your client aware of that. Now, of course, they can come back, and I'm getting far afield from divorce. I apologize, but I'm just trying to tell y'all things that your clients might run up against. You can go back to the court where the divorce was filed and pursue an enforcement because he or she failed to pay on something that they were ordered to pay on. But that in and of itself could be a long, drawn out affair that you have to deal with. So just make your clients aware of that if debt is divided and if both spouses' names are associated with that debt, even if the debt is awarded to one particular person, if that person quits paying on it, if it's enough money that whomever, like I love to use Dillard's because I like to use my Dillard's card, that if Dillard's would chase after you, then you may end up getting chased, even though you thought long time ago that you would get them, that you were rid of that debt because she was taking Dillard's and you were never having another Dillard's card again as long as you lived. And I just got a question, which I'm going to go ahead and answer. It says, documents were mentioned. Will we get a packet after the presentation? Yes, you should be emailed a packet. And I'll tell you what's in the packet just so you can make sure you get everything. It should be an original petition for divorce, an affidavit of inability to pay costs, a sample waiver of service, and a final decree of divorce. Oh, and it has prove up questions, and it has a sample affidavit for prove up in case you choose to do, well, let me rephrase that. If you choose to do, in case the court is allowing divorce prove ups by submission. And if the court allows divorce prove ups by submission, what that means is that when the court has proof that the original petition was filed, that the waiver of service was filed, or that there's service on file, that you can contact typically the court coordinator, but sometimes even the clerks, and ask if the judge is doing divorce prove ups by submission, or are they doing divorce prove ups only via Zoom in-person prove ups, which are essentially like, if y'all haven't done them, but essentially like doing a prove up in person in court, but it's just via Zoom. Now, the other thing that you have to do is, remember I mentioned earlier that you're going to find out some information that you'll need for this information on suit affecting the family relationship. You have to file that in anticipation of your prove up as well. You can't, most courts won't allow you to do a prove up without that being on file, because that's something that's required to be mailed to Austin, mailed or emailed. I don't know what they do with it, but anyway, somehow it has to get to Austin for every divorce prove up that's completed. So most of the courts will not allow you to do a prove up without that Austin form being on file. Let's see. If one spouse or debtor does not pay the Dillard's card and the other spouse's credit takes a hit, does the non-debtor spouse need to pay and ask for the money back? Yes, in truth, if my, as I said, I love my Dillard's card example. If I don't pay my Dillard's card and my ex-husband has to pay the Dillard's card in order to get a loan or do something where his credit needs to be improved, and so he says, she just ticking me off, she's doing this on purpose, she knows that I need to have good credit, then you can actually pursue an enforcement with the divorce court based on the fact that the credit was reduced and that he had to pay off that Dillard's card because I refused to pay it, 2 years down the line after the divorce. So even though the court doesn't keep jurisdiction of divorce cases, they do keep jurisdiction for purposes of being able to pursue an enforcement. But you need to double check the code, because with regard to property, non-real property, personal property only, the jurisdictional limitations are, I believe, 4 years, but do not quote me on that. If I'm lying, I apologize, but I think it's 4 years. So you may want to see how long it's been. And of course, you still might have the right to pursue that person, even if it's been longer than an enforcement is allowed to lie in the divorce court. You may be able to pursue them in JP court or county court for that. If your client has recently been, I'm going to say, injured by failure to make payments. So if you're 6 years down the road and I'm still not paying that Dillard's card and the divorce court doesn't still have enforcement, that doesn't mean that you might not be able to trigger something through the county court because you had to make payments after the divorce court would have lost its jurisdiction even for the enforcement of property. So I hope I didn't make that even more confusing. So let me whip on through the rest of this, and then if other people have questions, I am happy to answer them. So let's see, we've gotten the original petition filed. We've gotten either the waiver signed or we've gotten him served at this point. So now it's time for you to write up the final decree of divorce. I've given you all an example of the final decree of divorce in the packet. So use that, but feel free to tailor it to your individual case. As I said, you want to find out if there's, if the pots and pans need to be divided, if somebody's in love with that couch in the back den, if somebody's, just dying for that, big screen TV that's in the front room, you need to make sure that those things are individually awarded to them. The other thing that you need to put in there is a date by which such things either need to be exchanged or a date by which the other person is allowed to come into the house or the apartment or the condo or the whatever in order to pick those things up that they are awarded, or you need to acknowledge in the decree that they've already received them. Because if you have to go, again, we're talking enforcement, and I apologize that we're kind of running far afield. If you have to pursue enforcement in order for, her to get that big screen TV that she wanted out of the living room, the court can't enforce if there's not language in there that makes it enforceable. And by that, I mean, it says, I'm going to use my own name, Elaine Mosier is awarded the big screen TV from, the front room, and it's a Sony. I can't even think of what kind of TV there is, but let's say it's a Sony and fancy TV. She has to pick that up on or before March 15th at 5 p.m. So you need to put some language like that if they don't already have these items in their possession. If they do have them in possession, all you got to do is put Elaine Mosier is awarded the Sony TV in her possession. If there's something that needs to be very specifically awarded. I see another question. The Austin form has to be submitted to the court to file with Austin before the hearing. Yes, before the final decree of divorce, you want to get that Austin form on file, because in order to do a Zoom hearing or a hearing by submission, you have to file your final decree of divorce. You have to file the Austin form with the court typically before they'll even set you for a prove-up date. Or if it's by submission, you have to file your final decree of divorce, file your Austin form, file your affidavit for submission, and then typically I will also email all those documents to the court coordinator. They probably secretly cuss me out for doing that. And I'll say, this is everything that I've gotten filed. And some coordinators will say, let me know when it's accepted, and then we'll, submit the final decree to the judge for signature if it's by submission. Or if I email them everything and say, hey, I've filed all this, they will then typically give me a prove-up date via Zoom if it's going to be a Zoom hearing. What if the only assets to be divided are retirement accounts like 401ks? Is the process the same for bank? No, it is not. 401ks are not, any retirement vehicle is not easy to divide. Typically, you have to utilize what's called a quadro, a qualified domestic relations order. There are people who specialize in doing nothing but writing quadros because companies are extremely cautious about dividing 401ks or other retirement plans. And they have to be, those quadros or qualified domestic relations orders must be done in a very particular way in order to meet the requirements of ERISA. and companies can get sued if they divide something and it's not divided properly under ERISA. So trust me when I tell you, they are going to be hyper careful about reviewing a quadro to make sure it meets all of the requirements. So if a quadro is needed, I strongly suggest that you find someone who does quadros for a living, and just tell your client they're going to have to pony up that money to pay for that quadro to be completed. And what you need to do during that 60-day period, if you have a 401k or you have a retirement plan that needs to be divided, you need to find that out up front. That's one of those questions you need to ask. Do you have a retirement plan? So you have a retirement plan. How do you know how much is in it? Are you each going to keep your own, or are you wanting them to be divided? And if it needs to be divided, start working on that as soon as possible, because it takes let's see. Miss Mosher seems to be using an outline. I apologize. I distracted myself because a question popped up. Miss Mosher seems to be using an outline with some date references as step-by-step. I think I sent that to, I think I sent that little checklist to Marcella. So y'all should be able to get my little cheat sheet to look at as well. And I put some things in there, but honestly, I didn't put the information that I'm giving you about 401ks right now, that you need to find somebody who handles 401ks. The person that I use is a woman named Rachel Paralisi. She's wonderful. But I strongly suggest that if you need to divide a retirement account, that you get in touch with someone who does quadros, so that you don't mess it up, because you don't want to mess that up. I think that's all the questions. Can I spell Rachel's last name? Parolisi. Okay, I'm going to go back to my cheat sheet. Okay, so you figured out everything that you need to divide in your final decree, whether it's the pots and pans, whether it's the quadros, whether it's a house. If it's a house or a piece of land, I'm going to hearken you back to your law school days. Land is never described by a physical address. A physical address can be used for purposes of reference, but you must have the legal description of the property in your final decree of divorce if you're trying to divide a piece of land or a house, or a condo or a townhouse, because those two are treated as if they're as real property. They are real property. So don't think you can just put, John is awarded the house on Main Street, 1425 Main Street. That doesn't work. You have to get the legal description in there. So once you've got your original petition filed, you got your waiver, or you have your proof of service on the opposing party, you get your final decree done, you get your Austin form filled out. And oh, by the way, there is an Austin form that's in the packet that I sent out. Then you connect up with the court coordinator or the clerks. You find out when you can either set this for prove up, or if the final prove up can be done by submission. I gave you an example affidavit for proving up by submission as well. Now, one of the things that has changed slightly, because no one does in-person prove ups anymore, is you don't walk out of court with a signed copy of the final decree of divorce. Typically, what you have to do is, a lot of times I just send my client down there to get a copy. Here's why. If they go down the day that the divorce was finalized, they can get a certified copy from usually from the clerks, but maybe even the records division downstairs, and it's free. If they don't go the same day, they'll have to pay for it. And I think it's $1 a page, whether it's certified or not certified. They need a certified copy of their final decree of divorce. There will be some reason, I don't know what that reason is, but there will be some reason 10 years after they've gotten divorced that they'll need a certified copy of it. So they need to just get one. I usually tell people get 2 if you can. Also, if you're dividing a retirement account, you're going to need about 4 certified copies, because I don't know why this is Rachel world for me, Rachel Paralisi world for me. The companies all want 3 or 4 certified copies of a final decree of divorce when they are reviewing the quadro, or pardon me, not when they're reviewing the quadro, when they are actually doing the division of the retirement account. So they need multiple copies, multiple certified copies of the decree of divorce when you're dividing by quadro. So just keep that in mind. Oh, and let me tell you one more thing. And again, I know I'm going far afield from simple divorce, but I'm gonna tell you anyway. Just have a note in the back of your brain. Typically, military retirement does not require quadro. It can be divided in a final decree of divorce, but you better make sure that it's approved in advance before you get the final decree signed, because that too is a huge nightmare mess, and you have to go back and do a nunc-pro-tunc and fix things, and it's all just, you don't want to do that. So you want things to be approved in advance. Now let's see, I've told you to send your client down there. Also, the courts typically won't email a plain copy to you. I don't know why, but they don't. But you can request a plain copy via email. You'll still have to pay for it, but you can get that from DC Records 2 at dallascounty.org. And you give them the credit card, and usually they send it to you the very same day. So that's easy enough done. And then you'll have a copy for your file, because you won't necessarily need to keep a certified copy in your file, because if you're like everybody nowadays, you scan everything and just have it in your computer, or have it on a thumb drive, or you have it somewhere that's not paper form. So if you have a scanned certified copy, doesn't count. It doesn't. If you then print it out, it's still not considered a certified copy at that point. Let's see. I never had to file an Austin form in Dallas County. Have they been letting this slide recently? My answer would be yes. Someone has been kind to you and letting it slide. Sometimes clerks will fill them out, because if you use a combination of the original petition for divorce and the final decree of divorce, you typically have all the information you need for an Austin form. So it may just be that you've been lucky and running across a nice clerk that will go ahead and answer. And oh, thank you, Michelle, for putting Rachel's name in there. Also, I wanted to let y'all know that most of the circumstances that I've described to you don't happen. Most of the time when people come to you for a simple no kids divorce, it's just a simple no kids divorce. They don't have any children that were born during the marriage, not to the spouse, not to anybody else. I'm coming at this from the woman's perspective. Oh, by the way, only because somebody asked me this question one time, if a man has a baby with another woman, but it's during his marriage, I'm going to use my husband and I as an example again. If my husband goes and has a baby with another woman while he's married to me, that is not considered a child of the marriage. That's just, now that might be a child of that other woman's marriage, but it's not a child of our marriage. So we don't have to worry about that child as far as getting a divorce is concerned. However, if I have a baby with another man while I'm married to my husband and we decide to get divorced, we have to do something about that child that I had with that other man, because that child is presumed to be a child of my marriage to my husband. I hope that was not super confusing the way that I said that. So I think that I'm done with all the steps, and hopefully everybody will get emailed all the documents and the cheat sheet. And I'm like 99% sure that I sent the cheat sheet to Maricela. And if I didn't, she's awesome. And Maricela just posted up the course number, and I'll say it as well. It's 174-148-590. And Maricela did say that she'll send you everything. And if nobody else has any more questions, I'm going to give you about 5 or 6 minutes back. Or if you do have